On August 2, 2026, another major layer of the European Union's AI Act starts to apply. But the headline that the AI Act arrives in August hides several different timelines. Transparency obligations expand this August. The final digital omnibus text sets December 2, 2027, for standalone high-risk AI systems. It sets August 2, 2028, for high-risk AI embedded in products covered by sectoral safety legislation. But as of July 17, 2026, that amendment has been adopted and signed and is still awaiting publication in the official journal. It enters into force on the third day after publication. So this is a dated briefing. Recheck the official journal before relying on the amended dates. What changes on August 2, and what controls should companies build now? First, the timeline. The AI Act entered into force on August 1, 2024. Its first obligations began applying on February 2, 2025. These included prohibited AI practices, core definitions, and AI literacy requirements. Rules for providers of general-purpose AI models began applying on August 2, 2025. Then comes August 2, 2026. The current official implementation timeline says the majority of the Act becomes applicable, and enforcement starts for the rules already in scope. The transparency rules reach far beyond systems classified as high risk. People must generally be informed when they are interacting directly with an AI system, unless that interaction is obvious. Article 50 contains specific exceptions. Article 50, paragraph 2, generally requires providers of systems that generate synthetic audio, image, video, or text to mark outputs in a machine-readable format so they are detectable as artificially generated or manipulated. The rule includes technical feasibility language and specified exclusions. There is a transition. Relevant systems placed on the market before August 2, 2026 have until December 2, 2026 to meet Article 50, paragraph 2. Systems placed on the market from August 2 do not receive that legacy transition. Article 50 also creates disclosure duties for deepfakes and certain AI-generated or manipulated public interest text. Those duties contain defined exceptions, so the content, context, and responsible legal role all matter. The direction is clear. Companies need to know where AI is used and which transparency rule applies. The first action is to build an AI inventory. Its scope should include centrally purchased platforms, embedded AI, and employee-created automations. That means recruitment tools, customer service software, fraud systems, marketing platforms, and productivity applications. For every system, record its purpose, users, data sources, vendor, underlying model, and accountable business owner. Also record whether it generates content, affects decisions, or sits inside a regulated product. The inventory is what allows legal roles and applicable obligations to be assessed. The second action is to identify your legal role. The Act distinguishes providers, deployers, importers, and distributors. A customer using a third-party service may be a deployer. The facts determine the role. Placing an AI system on the market under your own name or trademark may make you its provider. For high-risk systems, using your name or trademark, making a substantial modification, or changing the intended purpose so the system becomes high-risk can also shift provider responsibility. Do not classify only the technology. Classify what your organization is doing with it. The third action is to implement transparency controls. A disclosure policy does not operate itself. Decide where an AI interaction notice appears and who tests it. Decide how machine-readable markings are created, retained, and checked. Separate new systems from pre-August systems that use the December 2 transition. Define who determines whether content is a deepfake or public interest text and which exception applies. Then keep evidence that each control operated. The fourth action is to fix procurement and vendor contracts. A vendor's compliance statement does not replace the customer's own role-specific duties. Where relevant, companies may need documentation, logging, model change notices, incident reporting, content marking, and regulatory cooperation. The contract should provide the information and rights needed to operate the system lawfully after purchase. The fifth action is to assign evidence ownership. Assign named owners for inventory records, role decisions, AI literacy measures, disclosures, incidents, and exceptions. Evidence ownership should sit with people who can retrieve the records, not only with a policy team. If no one can retrieve the record, the control cannot be demonstrated. The key point is simple. The AI Act has one framework, but several application dates. Some rules already apply. General-purpose AI obligations began applying in August 2025. The majority of applicable rules and transparency duties expand on August 2, 2026. December 2, 2026 is the transition deadline for relevant pre-existing systems under Article 50, Paragraph 2. The signed amendment sets December 2, 2027 for standalone high-risk systems once it enters into force. It sets August 2, 2028 for high-risk systems embedded in products covered by sectoral safety legislation. Machinery products follow a separate sectoral route and should not be bundled into that list. Prepare in the right order. Build the inventory. Identify your role. Implement transparency controls, including the new versus legacy distinction. Fix the contracts and assign evidence owners. And before publication or a compliance decision, recheck the official journal. In regulation, procedural status is part of the fact.